Good morning, everyone. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, September 6th, 2023. The time's 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka, as well as our General Counsel, Mary Smith, and I'm John Neerman. For those of you who are joining us virtually, I'll ask that you please keep your microphones muted when you're not speaking. And for those who are making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you would like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, your affiliation, and the item that you'd like to speak to, and we will do our best to accommodate the request. With that, I want to thank everyone for being present today. And Ms. Smith, I understand the parties are still trying to log into get online to speak to item 1, so why don't we call item 2 first?
So item number 2 is the application by Mondo Concrete Partners, LLC, for issuance of air quality standard permit for concrete batch plant registration number 168180. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So, colleagues, as you're well aware, Texas Health and Safety Code Section 382.058C mandates that only those persons who permanently reside within 440 yards of a proposed concrete batch plant may receive a contested case hearing, and none of the numerous requesters on this item reside within 440 yards. There was also a request for reconsideration, but it does not raise new facts that would warrant a rehearing. So I believe we're compelled to deny the request and issue the permit.
I'm in agreement.
Likewise.
I've got a motion then. I would move that we deny all hearing requests and requests for reconsideration. Issue air quality standard permit for concrete batch plant registration number 168180 to Mando Concrete Partners LLC as recommended by the Executive Director and adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, should we go to 3?
Yes.
Yeah.
Item number 3 is the consideration of the application for renewal of TPDS permit number WQ00119130001 by Northwest Freeway Municipal Utility District. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, on this one, I agree with the Executive Director and OPIC that the renewal here is a so-called no increase renewal under Texas Water Code Section 26.028D, such that there is no right to a hearing. So I would deny the request and issue the renewal.
Yeah.
I'm at the same point, and I would move that we find that there is no right to a hearing on this application pursuant to Texas Water Code Section 26.028D. I move that we deny the hearing request of Dustin Lindsay, and I finally move that we issue the renewal of TPDES permit number WQ00119130001 to Northwest Freeway Municipal Utility District as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. How are we doing on the parties on item 1?
I think we should go to 4.
Okay, item 4.
Item 4 is the application for the creation of Rockwall County Municipal Utility District number 11. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So colleagues, as you know, we analyze requests for hearings on MUD applications under Chapter 55, Subchapter G of our rules. And the question is whether the requesters have identified a personal justiciable interest. And here I agree again with the Executive Director and OPIC that both the City of Royce and Rockwall County have done so. The proposed MUD would be located in Rockwall County and within the city's ETJ. Both the city and the county have articulated relevant and material interests, including impacts to city and county services. And the requesters have also met the procedural requirements under Subchapter G. So I would grant these requests.
I agree.
Likewise.
I would move then that we grant the hearing request of the City of Royce City and Rockwall County, that we refer the matter to SOA for a contested case hearing on the petition, and that we refer this matter to the Commission's Alternative Dispute Resolution Program, excuse me, to run concurrently with the SOA preliminary hearing scheduling process.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, let's go to item 5.
If you'd like, we can go to 1 now. I think our parties are all here online.
That's fine. Let's do 1.
Okay. Item number 1 is the ALJ's proposal for decision and order regarding an enforcement action against Antonina LLC doing business as Food and Fuel Express. The order of presentation will be the Executive Director, followed by the respondent, the Office of Public Interest Counsel, and then the ED may reserve time for rebuttal as the ED bears the burden of proof in this matter. So we'll begin with the ED.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, Public Interest Counsel. I'm David Cagle, an attorney in the Litigation Division, appearing on behalf of the Executive Director. The Executive Director recommends adoption of the proposed order in this matter as modified by the exceptions letter. This enforcement action involves 1 violation for failing to conduct annual Stage 1 pressure vacuum and pressure decay tests. After an evidentiary hearing in June 2023, the ALJ found that the Executive Director proved that the respondent was the owner and operator of the facility and committed the violation. The ALJ also found that the ED's recommended penalty of $3,000 was calculated in accordance with the Texas Water Code and TCEQ's penalty policy. The ED did not seek corrective action because the respondent came into compliance in January 2021 by conducting a Stage 1 test with a passing score. The ED filed an exception to address a non-substantive issue, and the ALJ agreed with the ED's exception. The Executive Director asked that you adopt the proposed order as amended by the exceptions letter. Here to answer any questions you may have and reserve the remainder of my time for rebuttal if necessary.
Thank you, Mr. Cagle. I have none. Colleagues, any questions? All right, let's hear next from the respondent. Is Mr. Elbaya here?
Yes. Yes.
Sir?
Yes, sir.
Yeah, go
I'm
ahead
here.
and state your name and then the floor is yours.
Okay. My name is Pierre Elbaye, and I am the operator of Food and Fuel Express in San Marcos, the store in questions for this violation. Good morning, Mr. Chairman and General Counsel. I'm going to be brief about this. In a normal time, this would be more than just the penalty and the violation. But in this time today, it's fine. But I want to go back 2 years ago to 2020. I've been saying this, that we were in a very difficult time. We were under COVID. Everything was postponed. We were asked to stay at home. We were asked to do business as minimum. We were trying to stay afloat as much as we can. We had manager not showing up, employee not showing up. It was very, very difficult and hard time for us. I have been in this business for 30 years. I have more than one store, more than one location. I have never had any violation with the ECQ. I have always been, good, no violation, no penalties for 30 years. The only reason why I'm contesting this is because that store, it's more than one thing happened at that particular time that caused this test not to be done or delayed. First, I bought that store in February 2020. That's when we were doing the paperwork, which is the peak of COVID, and we did not know anything about it. I did not get my delivery certificate to operate that store till June. I get the audit in December. We had me and the inspector, and on the site we went and checked because we have electronic equipment that tests everything. We thought that also that test could be done through the equipment that we have. Unfortunately, it was not. Then I immediately ordered the test. So the test was like 4 weeks late. If it was done on December 6th, for example, then I would not have any violations. It was done on January, I believe, 13 or so. So all what I'm asking today is, this was difficult time. That was the reason why we were delayed. We did not go to work. We were, it was just crazy things. I'm asking you guys to understand this. And even though recently that store was again audited, it was supposed to be audited in December. We had that audit in August, which was about 5 months ahead of the normal audit, and we were in compliance. The test, every year these tests been done, even more tests than the ECQ is requiring. Hayes County has this test mandatory for the vapor testing. In other counties that I have, it was not. It was not mandatory, and this is what kind of also put me off doing these tests. So all what I'm asking today is, it was tough time. It wasn't normal time. Please consider this, and thank you.
Thank you, Mr. El-Baye. I do have maybe a few clarifying questions for you. You spoke about an audit, and I think I heard you say that there was an audit in June, and was there a second audit in August? Two audits, or just?
Oh no. This year in 2023. Normally the audit they do every December. That's when we had our audit, because they do it every 3 years. This audit for that particular store was done this year in August, and we comply with all the we're fine. That's what I meant.
Thank you, sir.
The audit that was done in question, it was in 2020.
Okay, I got you. Thank you, sir. Colleagues, any questions for Mr. El-Baye?
No, thanks.
Okay, let's hear next from OPIC.
Good morning, Chairman, Commissioners, General Counsel, and Executive Directors, attorneys, and staff. I'm Jennifer Jameson on behalf of OPIC for the record. OPIC agrees with both the ALJ and the Executive Director that the record supports a finding that Respondent Antonina LLC failed to conduct annual Stage 1 testing during 2020 and that a $3,000 penalty is appropriate. OPIC notes that Antonina does not contest the violation itself, but instead advocates for a lower penalty based on deficiencies in the previous owner's record keeping and because COVID-19 affected its business operations. The record shows, and Respondent agrees, that Antonina was responsible for Stage 1 testing, and Respondent did acknowledge that TCEQ retains testing records that could have cleared up any confusion caused by the prior owner's record keeping, but Respondent did not ask TCEQ for them. Further, ED witnesses sufficiently established that the required testing was attainable despite COVID-19 restrictions, and the vast majority of gas station inspections in the region at the time were completed without issue. Finally, the evidence shows that TCEQ staff followed its penalty matrix and correctly concluded that the failure to perform Stage 1 testing presented a potential moderate harm, which translates to a $3,750 base penalty and ultimately a $3,000 penalty after adjustments for Respondent's past performance and response to its violation. Accordingly, OPIC recommends adoption of the ALJ's proposal for decision as amended by the exceptions letter. Thank you.
Thank you, Ms. Jameson. Colleagues, any questions for OPIC? All right. Mr. Cagle, you've got some time for rebuttal if you want to respond to anything that you've heard.
Yeah. I'll cede the rest of my time.
Okay, thank you, sir. Colleagues, on this one, and I appreciate Mr. El-Baye's long history in this industry and his efforts to comply. That said, other than some minor corrections, I don't have any reason to overturn or to change, I should say, the ALJ's proposal for decision. And if you'd like, I can read those corrections into a motion and we could discuss it on the other side.
That works for me.
Go ahead.
Okay. Colleagues, I move that we adopt the administrative law judge's proposed order with the following modifications. Modify finding of fact 13A as recommended by the executive director's exceptions and agreed to by the administrative law judge's reply. Modify finding of fact number 17 to identify October 2021 as the correct date that the executive director filed the EDPRP. Replace finding of fact number 18 to state, quote, between October 2021 and February 2022, the respondent communicated with the ED and filed an answer that requested a hearing, end quote, to correct the respondent's answer history. And finally, correct the spelling of Jamison, Jamison, in finding of fact 23 to accurately identify the OPIC's representative at the hearing. And that, colleagues, is my motion. Any discussion?
No, I would second the motion, but before I officially do that, I'll let my colleague weigh in.
I'm in agreement as well. Happy to vote in favor of that motion. I appreciate Mr. Elbaye coming and advocating for himself and pleading his case. I think that it would be inappropriate and inconsistent for us to act in response to that request, and I'm happy moving forward.
All right, I've heard a motion and a second.
I will second, yes.
So all those in favor say aye.
Aye.
Aye, the motion carries. And Ms. Smith, I think we're on item 5, if you'll call that.
Item number 5 is a petition for the creation of 290 Betka Municipal Management District Number 1. 290 Betka LLC, the petitioner seeks the district's creation and so should present the matter, followed by any interested persons. Presently, we have no one signed in. And then the ED and OPIC. OGC recommends limiting the parties to 5 minutes for their presentation, and the petitioner may save time for rebuttal as they bear the burden of proof. So we'll ask the representative for the proposed district.
Good morning, and I'll ask you to double check the mic and make sure you've got a green light. in front of you.
Testing,
All
testing.
right, we're
All
good,
right.
we're good. Go ahead, sir.
Good morning, Mr. Chairman, Commissioners. For the record, my name is Jeffrey Earl. I'm an attorney with the Earl & Associates Law Firm out of San Antonio. I represent 290 Betka LLC, the owner of the property within the district. This is a petition requesting that you create 290 Betka Municipal Management District Number 1. It is 265 acres. It is all located within the ETJ of the City of Houston. The city has consented to creation. The planned use is a Class A industrial business park, which will create jobs, commerce, and provide much-needed support for the supply chain within the state, which is in line with the stated purpose of 375, which is to promote and benefit commercial development within the state. With us virtually, in case you have specific questions about the development, is the project lead, and we'd be happy to answer any questions you may have.
Thank you, Mr. Earl. I have none at this point. Colleagues, any questions?
I wonder, Mr. Earl, if you might just add a
Sure.
little extra detail for me. Is there any significance in the proposed district's intention not to utilize any bonds, but instead to follow a route of using an assessment directly and a different method of financing? I'm curious if that's indicative of future business needs. We might need to expect to see that with other district matters in the future.
Yeah, I think just with the interest rates being what they are, the bond market is pretty tough. And so being able to utilize those assessments as a statute allows creates more flexibility in private finance, and then the ability to repay those with assessments.
I appreciate the significance of that current interest rate detail. So that fills in some answers for me. Thank you.
Yes, sir.
Thank you, Mr. Earl.
Thank you.
Let's hear next from any interested persons.
And no one has signed in.
No one signed in. Okay,
Yeah.
the executive director then.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Bobby Salehi with the Environmental Law Division, representing the Executive Director. With me today is Justin Tack from the District Section. The Executive Director received a petition from 290 Betka LLC for the creation of 290 Betka Municipal Management District Number 1 pursuant to Chapter 375 of the Texas Local Government Code. The ED recommends granting the petition for the district creation. We're available for any questions you may have.
Thank you, Mr. Salehi. I have none. Colleagues, any questions? All right, let's go to OPIC. Mr. Arthur.
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC agrees that the petitioner has satisfied the applicable requirements of Texas Local Government Code Chapter 375, Texas Water Code Chapter 49, and Texas Administrative Code Title 30, Chapter 293. Specifically, the district is feasible, necessary, and would benefit the public. Therefore, OPIC supports granting the petition for creation of Betka Municipal Management District Number 1 in Harris County.
Thank you, Mr. Arthur. Colleagues, any questions for OPIC? Seeing none. Mr. Earl, I'm not sure there's anything in there to rebut, but if you have any additional thoughts, I'll give you that opportunity. Okay, we're good. Colleagues, as you know, we consider petitions for the creation of municipal management districts under Chapter 375 of the Local Government Code, and based on the uncontested petition before us and the Executive Director's technical memorandum, I would grant this petition. It does appear to meet the minimum content requirements, the relevant notice requirements. The initial directors appear to be qualified, and the Executive Director's proposed order appears to be appropriate. Commissioner Lindley.
I'm in agreement.
Likewise, I make the motion that we grant the petition for the creation of 290 Betka Municipal Management District Number 1 in Harris County and issue the Executive Director's proposed order for creating the district and appointing the 5 initial directors.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the application by Golden Triangle Polymers Company, LLC, for authorization to construct a new wastewater treatment facility. The parties have been notified that they would have 5 minutes for presentations. The applicant, Golden Triangle Polymers, should speak first, followed by any interested persons. Currently, no one is signed in on this one. The ED, and then OPIC. And the applicant may save time for rebuttal as it bears the burden of proof. And so I guess we would begin with the applicant, and I believe that's Chad Jennings.
Good morning, Mr. Jennings. Mr. Jennings, let me interrupt you. I'm not sure we've got you on the mic.
Thank you. It's clear now?
There we go. Yeah, we
Okay,
got you.
thank you for
sir.
verifying. All right, good morning, Chairman and Commissioners, General Counsel, and representatives of the Executive Director and Public Interest Counsel. I am Chad Jennings, Plant Manager of the new Greenfield Golden Triangle Polymers plant being constructed in Orange, Texas, as well as Vice President of Golden Triangle Polymers Company. Golden Triangle Polymers is here this morning to respectfully request approval to begin construction of the wastewater treatment facility at the plant. Golden Triangle Polymers has submitted a TPDES permit application to authorize the discharge of up to 5.2 million gallons per day of treated wastewaters from the petrochemical plant. The plant will consist of 3 manufacturing units, including an ethane cracker and 2 high-density polyethylene units. The discharge will be by pipeline to a submerged outfall in a tidal portion of the Sabine River located adjacent to the Port of Orange, Alabama Street Terminal. Golden Triangle Polymers appreciates the Commissioner's consideration of the request and recognizes that these requests are not common. I would like to say up front that Golden Triangle Polymers intended to file the TPDES permit application with ample time for its processing prior to construction of the wastewater treatment facility. Once it became apparent to the company that a discharge of treated industrial wastewater to Cow Bayou or Adams Bayou, the 2 closest water bodies, would not be an option due to ongoing work on the total maximum daily loads for those waters, Golden Triangle Polymers worked diligently to identify an appropriate location for the discharge. Golden Triangle Polymers identified potential options for the discharge at both the Neches River and Sabine River. Many potential locations, approximately 25, were evaluated and rejected for various reasons. Some locations on the Sabine River were extensively evaluated and then rejected for technical or logistical reasons. Once a workable location was identified, additional time was necessary to negotiate agreements and identifying the suitable pipeline pathway to the discharge location. To keep the project on schedule, this request for approval to construct the wastewater treatment facility under Section 26.027 of the Texas Water Code was necessary. Golden Triangle Polymers fully acknowledges that approval of the request and subsequent commencement of construction does not in any way bind the TCEQ to issue the TPDES permit to the company. Also, if the TCEQ does issue a TPDES permit, Golden Triangle Polymers acknowledges that it may need to modify or upgrade the wastewater treatment facility from the currently planned design to achieve permit requirements. Golden Triangle Polymers also acknowledges that once this approval to construct is granted, expenditures it makes on the wastewater treatment facility are at its own financial risk, and that the equipment ultimately may never be used for a direct discharge from the facility to waters in the state. Most, if not all, of the wastewater treatment equipment that Golden Triangle Polymers will construct will still be useful to manage wastewater from the plant for indirect discharge, reuse, and/or off-site disposal. As described in the request, the wastewater treatment facility will be located on approximately 5 acres centrally located within the site. Because of the central location of the wastewater treatment facility, the delay in its construction will complicate scheduling and mobilization of approximately 4,500 construction workers that will be on site over the period of construction, and would delay by many months the startup of the petrochemical plant because its completion is dependent upon the construction of the wastewater facility. Once fully operational, Golden Triangle Polymers petrochemical plant will employ more than 500 people. So at this time, thank you for the opportunity to address you this morning. We are proud of the new petrochemical facility and the positive impact it will have on jobs and the economy in the area. Approval of this request will enable us to begin construction of the treatment facility and avoid delays in construction of the remainder of the petrochemical project. Thank you.
Thank you, Mr. Jennings. Colleagues, any questions for Mr. Jennings?
Not at this time.
Thank you, sir.
Thank you.
Ms. Smith, has anybody signed in to speak on this item?
No one has signed in.
Okay, let's hear next from the Executive Director.
Good morning, Commissioners, General Counsel, Public Interest Counsel. I am Kathy Humphreys with the Environmental Law Division. Golden Triangle Polymers Company requested an authorization to construct a wastewater treatment facility before a TPDS permit is issued. According to Golden Triangle, the wastewater treatment facility will be located within the site, and delays to the construction of the wastewater treatment facility may complicate mobilization of facility equipment to the construction area. Additionally, the startup of the production facility is dependent on construction of the wastewater treatment facility. Texas Water Code Section 26027C provides that a person may not commence construction of a wastewater treatment facility until the Commission has issued a permit to authorize the discharge of waste from the facility, except with approval of the Commission. The Commission's authority to approve or deny a request for an authorization to construct is discretionary under the statute. The approval of an authorization to construct would not bind the Commission in its final decision. If the application is granted, Golden Triangle would be constructing. If the application is not granted, the Golden Triangle would be constructing the wastewater treatment facility at its own risk. After reviewing the application, the Executive Director finds that Golden Triangle has provided a valid basis for requesting an authorization to construct the wastewater treatment facility. Additionally, ordering provision number 6 references Golden Polymers rather than Golden Triangle. For consistency with the other provisions in the order, the Executive Director recommends changing Golden Polymers to Golden Triangle. Thank you, and I'm available for any questions you may have.
Thank you, Ms. Humphreys. I have none. Colleagues, any questions? All right, Ms. Smith, has anyone signed in to speak?
No.
All right, let's hear next from Mr. Wayne. Good morning.
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Director's representative. I'm Sheldon Wayne for the Office of Public Interest Counsel. After review of the materials associated with this matter, OPIC finds no reason to oppose the authorization to construct. Golden Triangle has demonstrated that it is necessary for efficient and expeditious construction of the overall project, of which the wastewater treatment plant is just one component. Additionally, the requester has acknowledged, both in their request and then here today, the limitations and risks of construction prior to a decision being made on their pending TPDES application permit. Therefore, our office does not oppose issuance of the authorization to construct. Thank you. I'm available for questions.
Thank you, Mr. Wayne. I have none. Colleagues, any questions for OPIC?
No.
Okay.
I do have one question. I wonder if OPIC or perhaps Executive Director staff may offer different views on it, but if we could pose it to OPIC. I'm curious, has OPIC done any work surveying, or are you aware of any communities in the public that you might anticipate there would be some responses or reactions to this permit as the technical details become a little better known to the surrounding whether fence line communities, anything like that.
Certainly. We haven't done any intensive surveys, but I did do a little bit of background check, and I didn't find that there was any public opposition. I also didn't find that there was any record of anything in the applicant's compliance history that would necessitate us to oppose this.
Thank you very much.
All right. The applicant does have an opportunity to offer any rebuttal. I see no interest in that. I'm not sure I heard anything to rebut in there. Colleagues, this is a request for extraordinary relief, and as you know, normally a TIPD's permit authorizes both beginning construction of a wastewater facility as well as the discharge from that facility. And here we're asked to allow construction before the applicant knows whether a TIPD's permit would be issued or the terms of any authorization that might be issued. And historically, we've sought to discourage these requests and have declined them unless there's a compelling reason to grant them. And this is a fairly straightforward case to me. You know, in the best of cases, these are always a little bit on the bubble. But my analysis is this: I think the applicant makes a reasonable case of the economic development benefits, including to the local community in Orange. And some of these will happen with or without an acceleration of the schedule or allowing them to keep their schedule. But I think there is value to the community in allowing the applicant to maintain their schedule. And we haven't heard any objections. Nobody signed in opposed to this item, and it sounds like OPIC has done a little bit of due diligence around that. So on balance, I'm in favor of granting this request. Commissioner Lindley.
I agree. I don't see a reason to oppose it, and so I'd be fine granting it.
I'm comfortable moving forward. I do want to just acknowledge I'm a little more nervous about this request relative to others that, at least two others I've seen directly, but reviewing the record and our past decisions, this seems to me that there's a request to authorize construction that comes a little earlier in the process, the permit application process, and where our staff are still actively participating in the technical review versus where they've issued a draft permit. And that's getting reactions and response from the public. I view that as two very different spaces where our agency engages. So I have some real concerns about our staff working on answering the questions relative to this particular permit in the context of the public expectation and appearance of us having authorized construction, allowed them to start putting sunk costs into what they think the permit will reflect and what the final design will be. I think I'm satisfied that the uses and the value of that plant will exist regardless of what our agency authorizes in terms of discharge directly to the state, and I'm convinced in their arguments and in the absence of any public interest or concern at this point in time that it would be a useful plant, and I think that addresses a lot of the potential concerns. I've sat in that position in our agency, and I very much respect the pressures of those construction deadlines and the looming things that are moving. So I don't want to delay. I don't want to ask for further information at this time, but I do want to acknowledge that I fully expect to see any concerns or interest from the public met with elevating and amping up the technical rigor applied to answer it rather than applying any resources to optics or public relations of it. I think that this is the answer to ensuring a durable and valuable facility like this one looks like it will be in terms of the need for our state's economy, and I'm good moving forward.
I've got a motion. I would move that we grant the application of Golden Triangle Polymers Company LLC for an authorization to construct and issue the executive director's proposed order, but correct the defined name of the applicant to Golden Triangle in ordering provision number 6.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next items.
Items 7 through 10 are the consideration of fiscal year 2024 proposed assessments for annual costs for Water Master operations in the Rio Grande Water Division, the South Texas Water Division, the Concho River Water Master Program, and the Brazos, sorry, I can't talk today, the Brazos Water Master Program. The Executive Director's staff is here to present these matters.
Good morning.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Jose Davila Pepe, Water Master Section Manager with the Water Availability Division. With me today are Aubrey Pavelka with the Environmental Law Division, Stephen Kino, and Ileana Spade with the Water Availability Division. Staff are here to request the approval of the fiscal year 2024 assessments for the 4 Water Master programs, Rio Grande, South Texas, Concho, and Brazos. We have prepared the assessments to cover costs of the Water Master programs, the increases in state employee salaries, and the additional increases for TCEQ employees translated into increases for all Water Master program budgets. South Texas program is to increase by 10.6%, Rio Grande program by 12.6%, Brazos program by 11.2%, and the Concho program by 12.3%. Our operational budgets remain relatively flat across fiscal year 23 and fiscal year 24, largely due to the use of budgetary savings to purchase vehicles, equipment, supplies, and services. Notice of the proposed assessments was provided to all water right holders in June. Water right holders were encouraged to attend and participate in the July Water Master Advisory Committee meetings. At the July meetings, assessment budgets were presented and feedback from the committees was considered. Ultimately, all 4 committees voted to recommend approval of the assessment budgets before you today. Thank you. We are available to answer any questions you may have on this item.
Thank you, Mr. Davila. I have none. Colleagues, any questions?
No question, just a quick comment. It's not fun to raise fees, it never is. And so I just want to commend y'all on doing the road show, for what I'll call it that. What y'all do, go around visiting with everyone, explaining it, and the fact that all the stakeholders seem to be okay with it, just goes to show, compliments the work y'all do. So good job, and appreciate what y'all presenting here today.
Thank you.
Thank you. Ms. Smith, has anybody signed in to speak on these items?
No one is signed in.
Okay, Mr. Arthur.
OPIC supports approval of the Rio Grande, South Texas, Concho, and Brazos Water Master budgets for fiscal year 2024 and issuance of the ED's proposed orders assessing the annual costs of those Water Master programs.
Thank you. Colleagues, these budgets come to us on the recommendation of the Executive Director, OPIC, and the Water Master Advisory Committees. The expenses and assessments appear reasonable to me, so I'm certainly ready to move forward with the budgets and issue the assessment orders.
I am too.
I'll provide a motion. I want to second Commissioner Lindley's sentiment and just express the gratitude that I have for the Water Master Advisory Committees, all the stakeholders that y'all worked with in engaging with that in a conversation. As I understand it, those costs and demands upon the program are likely to be rising and continuing to increase in coming years. And so I'm grateful for staff taking time and energy to try to flatten that curve, smooth it out, make it a little softer for the rate payers. This is a desperately needed and hotly contested commodity in our state, and is the absolute lifeblood. So I'm really grateful for the work that staff does, and this exercise. Everything we do is so interconnected. So it's not lost on me that we'll be revisiting this conversation in a greater context. But I'm very grateful for all the efforts from all directions. And I'll move that we approve the Concho River, Rio Grande, South Texas, and Brazos Water Master budgets for fiscal year 2024 and issue the Executive Director's 4 proposed orders assessing the annual costs of those Water Master programs.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, please call the next item.
Item 11 is the consideration of the Executive Director's findings and recommendations on whether a water master should be appointed for the Trinity River, San Jacinto River, Trinity San Jacinto Coastal, and Neches Trinity Coastal Basins. The Executive Director's staff is here to present this item.
Good morning again.
Good morning, thank you. Chairman, Commissioners, General Counsel, and Public Instrument Counsel. My name is Jose Davila Pepe, Water Master Section Manager with the Water Availability Division. With me today are Aubrey Pavelka with the Environmental Law Division and Ileana Spade with the Water Availability Division. In accordance with Chapter 11, Subchapter G, Sections 11.326 G and H of the Texas Water Code, the Executive Director is required to evaluate each river basin that does not have a water master program at least once every 5 years to determine whether a water master should be appointed. We are to report the findings and make recommendations to the Commission. During fiscal year 2023, we evaluated the Trinity River, San Jacinto River, Trinity San Jacinto Coastal, and the Neches Trinity Coastal Basins. The evaluation was based on the criteria and factors determined by the Commission. The three primary criteria evaluated were, number one, were there any court orders to create a water master? Number two, have any petitions been received requesting a water master? And number three, have senior water rights been threatened? 2 letters were mailed to stakeholders throughout the basins on March 10 and May 12, 2023, to notify them of the evaluation process as well as their ability to attend meetings and to offer comments. 2 stakeholders' meetings were held in person on June 5th and June 6th. 2 additional stakeholder meetings were held virtually on June 7th and June 8th. During the comment period, 12 opposed, 1 in favor, and 1 neutral comments were received for the Trinity River Basin, 2 opposed, 2 in favor for the San Jacinto River Basin, 4 opposed, 1 in favor for the Trinity San Jacinto Coastal Basin, and 4 opposed, 1 in favor for the Neches Trinity Coastal Basin. Comments received were made available in the agenda documents that were filed for today. With no court orders or petitions to create a water master during the 2018-2022 period, as well as no repeated history of threatened water rights, the Secretary Director recommends that the Commission not move forward on its own motion to create a water master program for the Trinity River, San Jacinto River, Trinity San Jacinto Coastal, and the Neches Trinity Coastal Basins. Thank you again, and we're available to answer any questions you may have on this item.
Thank you again, Mr. Davila. I have no questions. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
No one has signed in.
And Mr. Arthur, what does OPIC think?
OPIC appreciates the ED's evaluation and report of these findings and recommendations.
Thank you. Colleagues, this is part of our regular cycle to evaluate whether a water master program should be created for different waters in the state. As we heard in this case, none of the factors that would argue for a program are present, so I would recommend that we take no action on this item.
I agree.
All right. Thank you again, Mr. Davila. And Ms. Smith, when you're ready, I'll ask you to please call the next item.
Thank you.
Item number 12 is the annual review of financial assurance mechanisms and cost estimates for radioactive material license numbers R04100, held by waste control specialists. The executive director's staff is here to present this item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Chance Gooden with the Radioactive Materials Division. With me today is Audrey Leiter with the Environmental Law Division. In compliance with 30 Texas Administrative Code, Section 336-736C, waste control specialists' financial assurance mechanisms and cost estimates are reviewed annually by the Commission at an open meeting to ensure sufficient funds are available for completion of the low-level radioactive waste disposal site enclosure plan. Included in your backup materials is the Radioactive Materials License Financial Assurance Summary for waste control specialists for your review and approval. Thank you for your consideration. We're here to answer any questions you may have.
Thank you, Mr. Gooden. I have none. Any questions, colleagues? All right. Ms. Smith, has anybody signed in to speak?
Yes, we have one person signed in to speak, and the commission will limit initial comments from each speaker to 3 minutes. We have Karen Haddon.
Good morning. Ms. Haddon, I'll have you just double check to make sure that there's a green light on your microphone.
Yeah.
Okay. Yeah, we hear you loud, and these mics have been acting up today. Maybe a little bit too
Okay.
loud, but I think we're good to go. If you'll just please state your name again for the record, and then the floor is yours.
Good morning, Chairman and Commissioners. I'm Karen Haddon. I'm the Director of SEED Coalition, which is Sustainable Energy and Economic Development Coalition. And I appreciate that you're looking at this financial assurance annually. And I think it's really important. I think that, we have a lot of low-level radioactive waste coming into Texas, and we need to make sure that there's enough funding when it comes time to clean up. I would ask that you look at this again, revisit a bit, and consider whether the figure of $100.4 million is actually adequate. There are increased volumes of waste coming to the site. There's more nuclear reactors around the country shutting down, and most of that low-level waste is going to be coming to WCS. There's a possibility, and it's not being considered here, that greater than Class C waste could end up coming to this site, which is hotter, more dangerous waste, depending on what the NRC does in terms of recategorizing that waste. So I don't see that figured in. And this is the same number that's been used for a lot of years. Historically, when you look at other sites across the country, cleanup has cost billions of dollars, and it's quite possible that the same may turn out to be true here. In New York, there's a former reprocessing site. Granted, that's different, but that cleanup cost $9 billion, but the state of New York ended up spending $2 billion. So, and that's according to former NRC Commissioner Peter Bradford. So I urge you to look after the interests of the state, the economic interests. We need to be able to clean up if it comes time. And I urge you to consider raising the amount of financial assurance. Thank you.
Thank you, ma'am. Colleagues, any questions or comments? All right. Thank you for your comments. Appreciate that.
Thank you.
Ms. Smith, is anybody else signed in to speak?
No.
Okay, let's hear from OPIC. Mr. Arthur.
OPIC supports approval of Waste Control Specialists' financial assurance mechanisms and cost estimates as recommended by the ED.
Thank you. And colleagues, I appreciate the comments we just heard, and we'll just reiterate that this is an annual review, and to the extent that future conditions cause a change, we should definitely keep our eyes wide open. We appreciate those comments. As it stands now, there have been no changes in the condition of the site or the status of the site, or in the form of the financial assurance. And the amounts have been adjusted for inflation. So I think as it pertains to this 12-month review cycle, I'm ready to approve the financial assurance.
I'm in agreement.
Likewise, and to add one further point to that point you made, Mr. Chairman, I think it's very robust, in my opinion, where this agency has view of any future activities or future waste streams or future wastes that, if there were to be a change in authorization relative to the facility there, the agency would really need to evaluate if there was an impact in changing cleanup remediation costs, either corrective action costs, closure costs, things like that, where statute directs us, our agency specifically, to consider the different scenarios. And I'm satisfied that there is a very deep look that our staff will engage in and have the lever to make the decision. Is the financial assurance amount adequate? Does it require amendment or revision along with future amendments? And I would direct any interested members of the public, who I'm very grateful for their watching not just what this site and this program area is today, but what it could be tomorrow. I'm grateful for their interest, and I would encourage them to take a look at the details of that financial assurance that I believe is attached to a past license amendment, which reflects what I just described, our staff taking a very detailed look at the time that there was a change in activities presented to them as a request from this applicant, or for this regulated entity. So I'm comfortable where we're at today. I'm entirely where you're at, Chairman, and I think that you got a good handle on this, but there's a heck of a lot more interesting questions and interesting rabbit holes, and I don't think that there's nothing there to look at. So I'm grateful for the interest from the members of the public, and I hope that as our federal partners, our state partners in the private sector continue to grapple with this technical and regulatory problem, that we all are mindful of the changes that will come tomorrow and the day after that and the day after that. But I'm comfortable moving forward today as well.
I've got a motion then. I would move that we approve Waste Control Specialist financial assurance mechanisms and cost estimates as recommended by the Executive Director.
I second.
Motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 13 is the consideration of adoption of an amendment with renewal of TIPD's general permit number TXG 830000, authorizing discharges of petroleum-related water or contaminated water. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Shannon Gibson with the Water Quality Division. With me today is Audrey Pawelka with the Environmental Law Division. Staff requests adoption of a renewal with amendments of Texas Pollutant Discharge Elimination System General Permit Number TXG 830000, which authorizes the discharge of water contaminated by petroleum substances into or adjacent to water of the state from a variety of sources. The proposed permit will replace the current general permit that expires on September 12th of this year, 2023. Public notice of the draft permit was published in the Houston Chronicle on March 31st, 2023, and in the Texas Register on April 7th. No public comments were received during the public comment period. Staff recommends adoption of the general permit. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with the Texas Register requirements. Thank you, and we're available for any questions.
Thank you, Ms. Gibson. I have none. Any questions, colleagues? Seeing none, Ms. Smith, is anybody signed in to speak?
No one is signed in on this item.
Mr. Arthur.
OPIC has no objection to amendment and renewal of the petroleum contaminated water general permit.
Thank you, colleagues. The amendments that accompany this renewal are relatively minor. As we heard, there were no comments on the proposal. EPA had an opportunity to review the proposal. They lodged no objections, offered no comments. I'm comfortable adopting the renewal.
I would make the motion that we adopt the renewal with amendments of Texas Pollution Discharge Elimination System General Permit Number TXG 830000, relating to discharges of petroleum contaminated water as recommended by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next items.
That will take us to our enforcement docket, items 14 through 33, and the Executive Director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 14 through 33. The total assessed administrative penalties are $2,214,153, with $6,001 deferred, $2,051,688 applied towards supplemental environmental projects, and $156,464 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions? Ms. Smith, has anybody signed in to speak?
We have folks signed in on items 14 and 19 who are available to answer questions but don't wish to speak.
Okay. Mr. Arthur, what says OPIC?
OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. Colleagues, I do as well.
I would agree.
Likewise.
I've got a motion then. I move that we adopt items 14 through 33 as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 34 is the consideration for publication of and hearing on amended section 334.48 30 Texas Administrative Code. The executive director's staff is here to present the item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Zachary King with the Program Support and Environmental Assistance Division. With me today is Cameron Puckett, Staff Attorney with the Litigation Division, and Elizabeth Vanderwerken with the Program Support and Environmental Assistance Division. Since the beginning of the Texas Underground Storage Tank Program, inventory control procedures have been required under 30 Tax Section 334-48C, regardless of the release detection method selected by the owner or operator. The proposed rulemaking would amend 30 Tax Section 334-48C to remove the requirement for all retail service stations to conduct inventory control procedures. This change does not remove the requirement for inventory control to be performed as a necessary component for a release detection method selected under 30 Tax Section 334-50D4, which is the combination of inventory control plus automatic tank gauging, or 30 Tax Section 334-50D9, which is the combination of inventory control plus statistical inventory reconciliation. A public hearing will be offered on this proposal in Austin, Texas on October 19th, 2023. Staff respectfully recommends approval to propose the publication of and hearing on October 19th, 2023, associated to the proposed changes in Chapter 334 relating to underground and above-ground storage tanks. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you, Mr. King. I have none. Any questions, colleagues? Ms. Smith, has anybody signed in to speak?
We have people signed in, but they don't wish to address the commission, and their presence will be noted for the record.
Thank you. Mr. Arthur?
OPIC has no objection to publication of this proposal.
Thank you. Colleagues, it looks like the advances in leak detection practices may allow us to eliminate some redundant regulatory burdens, and I'm ready to put this out for public comment and see what the stakeholders think.
I agree.
I would move that we approve the publication of and hearing on amended section 334.48 of 30 Texas Administrative Code, Chapter 334, underground and above ground storage tanks, as recommended by the Executive Director.
I second.
The motion has been made and seconded. All those in favor say aye.
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 The motion carries. Ms. Smith, when you're ready, please call the next items. Will you lean your head out the window and tell them to knock it off? I think our window's done open.
So that takes us to items 35 through 40, the quadrennial rule reviews for chapters 1, 21, 115, 297, 329, and 342 of the Texas Administrative Code, Title 30. And the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Gwen Rico with the General Law Division. Pending before you are items 35 through 40, the adopted rule reviews of 30 Texas Administrative Code Chapter 1, Purpose of Rules, General Provisions, Chapter 21, Water Quality Fees, Chapter 115, Control of Air Pollution from Volatile Organic Compounds, Chapter 297, Water Rights Substantive, Chapter 329, Drilled or Mine Shafts, and Chapter 342, Regulation of Certain Aggregate Production Operations. As required by Texas Government Code Section 2001.039, Executive Director staff conducted a rule review of these chapters to determine if the need for the rules within these chapters continue to exist. The proposed notice of the review for Chapter 115 was published in the April 7th, 2023 issue of the Texas Register, and one comment was received. This comment was reviewed and determined to be outside the statutory or regulatory purpose of the rule review and will be considered when the rule is next substantively changed. Chapters 1, 21, 297, 329, and 342, published in the April 21st, 2023 issue of the Texas Register, with 30-day comment periods for all. No comments were received. Based on the review of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 1, 21, 115, 297, 329, and 342 continue to exist, and changes to the rules identified as part of this review process will be addressed in a separate rulemaking action in accordance with the Texas Administrative Procedure Act. In conclusion, we respectfully recommend approval of the adoption of the rule reviews of Chapters 1, 21, 115, 297, 329, and 342. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you. The project managers and attorneys assigned to these chapters are here with us to answer any questions.
Thank you, Ms. Rico. I have none. Colleagues, any questions? Okay, Ms. Smith, has anybody signed in to speak on any of these items?
Yes, on item 38, which is the rule review for Chapter 297, we have Destiny Rauschuber online.
And ma'am, you can go ahead when you're ready, and I'll ask you just please repeat your name for the record, and then the floor is yours.
Hi, can you all hear me?
We do.
Okay, perfect. Hello, Commissioners. My name is Destiny Rauschuber, and I'm a staff attorney with the Brazos River Authority. I am here today to comment on the review and readoption of 30 Text Chapter 29.7 concerning water rights. I am specifically concerned with the readoption of Rule 29.7.58b. This rule is as followed. It is, if a water right has appropriations with different priority dates, the oldest priority water shall be credited against the water first used unless the water right expressly provides otherwise, or the water right holder requested the water master to count the water used against the junior portion of the right. Essentially, this rule has the ability to allow, under a certain set of circumstances, an express right to account junior priority water before senior priority water. At the time of this rule's enactment in 1999, the BRA commented that this rule could be used to allow water right holders who apply for an express right to account junior priority water before senior priority water to reserve their most senior water for times of drought. I am here once again to express concerns that this rule could potentially be used by water right holders to request junior first authorizations that circumvent the prior appropriations doctrine, especially in a water master area. BRA believes that this rule, 297.58b, must be amended to accurately reflect that in a water master area, water right holders cannot request to amend their permit to have these junior first authorization, which we believe is more in line with the legislative history of this rule and will better protect existing water right holders. Thank you for your time, and I'm sorry I missed the first round of comments.
Oh, thank you for your comments. Appreciate you joining us today. Ms. Smith, has anybody else signed in to speak?
No one else has signed in.
Okay, Mr. Arthur.
OPIC agrees that the reasons for initially adopting the Chapter 1, 21, 297, 329, and 342 rules continue to exist, and we support readoption of the rules in each of those chapters. Regarding Chapter 115, OPIC recommends that EPA's comments be considered as general stakeholder input for possible future policy or rulemaking actions. With that recommendation, OPIC agrees that the reasons for initially adopting the Chapter 115 rules continue to exist, and we do support readoption of the chapter.
Thank you, Mr. Arthur. Colleagues, I agree that there is clearly a need for each of these rule chapters. There were no comments on 3 out of the 5 EPA offered comments on item 37, that's concerning Chapter 115. BRA, as we just heard, offered comments on item 38 concerning water rights. All of those comments are outside the scope of this particular rulemaking, but we will retain them to consider in future rulemakings. In addition, and I think this was noted, we found obsolete or incorrect provisions or both in Chapter 115, so we should initiate a rulemaking to address those.
I agree. I can make a motion then. I would move that we adopt the rule reviews and re-adopt the rules in 30 Texas Administrative Code, Chapters 121, 115, 297, 329, and 342 without amendment, and initiate a rulemaking to evaluate the repeal or amendment of sections of Chapter 115 that were identified as potentially obsolete or incorrect as recommended by the Executive Director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item 41 is the public comment session. The commission will receive comments from the public on any matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112. The commission cannot or will not receive comment on pending permit matters or other contested cases like enforcement matters, because these are subject to a prohibition found in the Texas Government Code. In the interest of time, speakers will be limited to 3 minutes each, with the total time for public comment limited to 1 hour. Please note that the commission's discussion of subjects for which public notice has not been given are limited to statements of specific factual responses and the recitation of existing policy. With that, we will begin with William Schwartz.
Good morning, Mr. Schwartz.
Morning. You hear me okay?
We can hear you. Yes,
Great.
sir.
As she said, my name's William Schwartz. I'm a CPA, and for over 10 years, I've owned a small chain of 3 emissions and safety inspection shops in Austin, Texas. We do about 100,000 inspections every year. I probably have more insight into the economics of the inspection business than anybody else in the state of Texas. I'm here to warn you about an impending crisis that you guys have not caused, but you're going to be blamed for. In 2025, when the price of a vehicle inspection goes down from $1,850 to $1,150, it will be virtually impossible to get an emissions inspection in the town of Austin and El Paso. More and more people are frustrated and can't register their vehicles, it will eventually be picked up by the news media. TCEQ will be blamed for this. I believe it will be a news event similar to the paper tag event recently and the ERCOT event of a couple years ago. You'll be forced to increase the price of an emissions inspection. So if you increase the price now, you can avoid the hassle for hundreds and thousands of drivers who won't be able to get an inspection, and more importantly, bad press for TCEQ. Here's an excerpt from a recent review at one of my shops. I tried several shops, but either their inspector wasn't working, only worked very limited hours, or they wanted me to set an appointment weeks in advance at an inconvenient time. Here I was in and out in 10 minutes. We hear this from customers many times a day, because even at $18.50, many lube and repair shops are cutting way back on their inspections. They can make much more money on a $100 oil change than they can on an $18 inspection. That takes about the same time. Imagine how much they're going to cut back when it's $11.50. When the safety part of the inspection goes away, my labor will increase to 92% of revenue. Myself and other inspection-only shops will gain some efficiencies from not doing the safety portion, but not much because we do the safety portion while the emissions computer is doing its job. So the efficiencies are minor. There's no way for an inspection-only shop to even come close to breaking even. My shop and other inspection-only shops will close.
By my calculations, inspection-only shops do approximately 20% of the inspections in Austin, Texas. These will go away, and there will be nobody to fill the gap. When the other guys cut back further, there simply will not be enough inspection supply to keep up with demand of people who need an inspection to renew their registration. It's simple supply and demand problem that we all learned about in our high school economics classes. Please avoid the debacle and raise the price of the emissions inspection to $22 now, which your own study indicated was the proper price 3 years ago. Thank you.
Thank you, Mr. Schwartz. Appreciate your comments.
And then next I have Jojo Hesselmeyer.
Good morning, Ms. Hesselmeyer.
Good morning, Chairman. Good morning, Commissioners, General Counsel. Last month was my first time before you, and I too brought an inspection issue before you, specifically to Bexar County. 2 issues with them. One is the date, the gap when safety inspections end and emissions begins for them. And then 2 was the price point set by TCEQ at $11.50. I just wanted to tell you guys today about a survey that TSIA did back in July. Specifically, we sent this survey to Bexar County inspection station owners. All the respondents seem to have an understanding that safety inspections are going away in January of 25. 60% of respondents said that they would be able to continue to operate their business after 1/1/25, while 40% said they would not be able to continue to operate their business after January 25. This seems to correlate to the 60% of respondents that said their business performed other services besides inspections, while 40% of respondents said their station was an inspection-only type business. The last question in the survey read, what is your current labor rate for a licensed vehicle inspector? 40% said $10 to $15 an hour. 45% said $15 to $20 an hour. 7.5% said $20 to $30 an hour. And then the other 7.5% said more than $30 per hour. Today, over 50% of the inspection stations pay over $15 an hour, making the proposed $11.50 again a challenge at best. Lastly, I want to highlight the most concerning survey question and the responses received. The survey question read, TCEQ is proposing $11.50 for the emission test in Bexar County. Based on the cost of the emissions equipment, will you offer emissions testing at your station? 10% said yes. 90% said no. Let me repeat that. 90% said they would no longer offer emissions inspections at the rate of $11.50. If this is realized, then Texas will have a large problem on its hands. This will affect DPS, TCEQ, DMV, all the county tax collector assessors that will have very angry customers in their offices, not to mention every Texan here in Texas. They'll all struggle to find an inspection station to perform their emissions inspection, and they will not be able to renew their registration. While Bexar County is the newest emissions program to come aboard and is my focus for today, I did want to highlight that we did this same survey to Travis, Williamson, and El Paso County inspection stations, and I'll share those at next month's meeting. So I will be back, as Arnold Schwarzenegger used to say in his
3
movies.
minutes.
So that concludes what I had to say today. Thank you so much for your time, and I look forward to seeing you next month.
Thank you, Ms. Hesselmeyer. We appreciate the repeat performance, and we'll see you next month.
We have 2 others who said they were going to be participating virtually but don't appear to be online, so I'll call their names and just confirm that. But the first
Okay.
is Lydia Ponce.
Ms. Ponce, are you with us online? Hearing nothing.
And then the next person is Cheyenne Rendon.
And I'm assuming Miss Rendon, are you with us? All right, well, as you,
Chairman, I don't show either online.
I'm sorry, say that again, please?
I don't show either one online.
Oh, thank you. Okay, I appreciate that. Well, of course, they'll have another opportunity next month. And I guess maybe we should meet the line to see if anybody else has comment. Okay. If there's anybody else who's joining us virtually who may have a comment for the commission, this is your opportunity to speak up. All right, hearing nothing, Ms. Smith, let's call the next items.
That takes us to our closed session, and the commission will meet in closed session in Building E, Room 211S at 10:50, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items number 42 through 45 as posted and noticed.
The time is 10:46 a.m. We are in recess.
The commission met in Building E, Room 211S for closed session from 10 a.m. until 11:10 a.m. on item numbers 43 through 45, as posted in notice pursuant to Texas Government Code Section 551074. No action was taken. This agenda stands adjourned, and the time is 11:12.